All right, I think we can go ahead and get started. We have a quorum. Thank you, everyone, for joining this evening. Judge Wilson, I'll turn it over to you, but I just wanted to let you know we do have a quorum for our commission meeting to begin.
Very good. And we've confirmed that the meeting is up and running for any member of the public that wanted to join in.
Yes.
Very good. All right. Well, I guess first order of business is just approval of the minutes from the July 7th meeting. Obviously, David and staff had sent that out in your e-packet ahead of time.
I would so move.
Very good. Thank you, Senator. Is there a second?
I'll second.
Okay. I'm sorry. Is there anyone in opposition? Hearing none, the minutes are accepted and approved. All right, Judge Avery, I think you're up. Guidelines Subcommittee report.
All right, thanks. Good evening. So the Guidelines Subcommittee did meet on August 31st, and we discussed the matters regarding the definition of a vulnerable victim under Part D of the offense score, as well as the ongoing issue relating to ABA pleas. And with regard to those two items, I'm going to defer to Dr. Soule.
Okay, thank you, Judge Avery. So the first item is the review of the definition of vulnerable victim under Part D of the offender score. The staff had asked the subcommittee to review this issue because of increasing questions about victim vulnerability, particularly with respect to whether someone who is intoxicated, under the influence of drugs or alcohol, or pregnant should be considered a vulnerable victim. More recently, the commission received an inquiry as to whether an incident involving a sleeping victim should be scored as a vulnerable victim. Under the Maryland sentencing guidelines, the offense score is calculated as the sum of points assigned to four elements: the seriousness of the convicted offense, victim injury, weapon presence, and special victim vulnerability. And with regard to that last component, the guidelines manual instructs that a score of 1 shall be assigned if the victim is a vulnerable victim, which is defined as anyone younger than 11 years old, 65 years or older, or having a temporary or permanent physical or mental handicap, including an individual who is physically or mentally limited in a material way. In fiscal year 2019, just less than 10% of person offense convictions were awarded 1 point for special victim vulnerability. To provide further insight into the cases that may involve a victim vulnerability, the staff also looked at the reasons for departure that were cited in guidelines cases. And as is noted in footnote 1 of the memo, special circumstances of the victim was cited as a reason for an above departure in approximately 10% of cases that were departures above the guidelines in fiscal year 2019. Now note that the worksheet also allows judges to provide other reasons for departures. And we reviewed our database and we found 13 sentencing events ranging from the entirety of the database, 2000 to 2019. And there were 13 instances in which a written other reason for departure cited a victim who was pregnant. That happened for 5 criminal sentencing events, intoxicated 5 sentencing events, or sleeping 3 events. In each of those instances, Part D of the offense score was recorded as 0 points. So in those 13 sentencing events, the guidelines were not calculated to account for it, but it was cited as a reason for departure by the judge. In September of 2018, the commission staff received a memo from the Howard County Domestic Violence Fatality Review Team, which is a unit within their state's attorney's office. In the memo, they argued that pregnancy should be included in the definition of a special victim vulnerability. They had initially planned to present that issue at the 2018 public comments hearing, but ultimately declined to present the issue for unknown reasons. More recently, an assistant state's attorney from another jurisdiction brought to the staff's attention that pregnancy may qualify an individual for short-term disability leave, the ASA argued that because the guidelines definition of special victim vulnerability includes a temporary handicap or disability, and because pregnancy may be considered a disability for insurance purposes, an offense involving a pregnant victim should receive 1 point for special victim vulnerability. The memo that we provide to you for today provides a summary about the definition of vulnerable victim from the federal and other state sentencing guideline systems. The sentencing guidelines in 8 states, including Maryland, the District of Columbia and federal system, make reference to victim vulnerability. Age and reduced physical or mental capacity or disability are included in each jurisdiction that references vulnerability. Pregnancy is referenced in the definition of victim vulnerability in the federal system, though only for certain drug offenses, and Michigan. Intoxication, sleep, and unconsciousness are referenced in the definition of victim vulnerability by one jurisdiction, which is Michigan. 7 of the states noted in the memo list victim vulnerability as an aggravating factor that justifies a departure from the guidelines. So the guidelines subcommittee reviewed the victim vulnerability issue at its August 31st, 2020 video meeting. And there are just a few main points of the debate. It was a lengthy debate, but I tried to summarize the main points that were made that I'd like to highlight. First, it was noted that the increased frequency of sex offenses perpetrated against women by friends, coaches, and family members suggests that the guidelines should be updated to reflect victim vulnerabilities beyond just age and disability as the current definition does. The second main point the subcommittee questions if the stage of pregnancy should factor into victim vulnerability. Because sometimes it could be difficult to determine if someone is pregnant based solely on their looks. The subcommittee questioned if it should also be interpreted whether the defendant knew about the pregnancy or a specific vulnerability. In regards to that point, the subcommittee generally agreed that the guidelines should not attempt to differentiate in any way between various stages of pregnancy. Rather, the subcommittee agreed that the new or reasonably should have known standard would apply to all victim vulnerabilities. Next, it was noted that some of the sentencing guidelines in jurisdictions outside of Maryland do not include factors that are elements of an offense. So they specifically would rule out an issue if it was an element of offense. Like for instance, if it was a crime against an elderly person, that couldn't be counted as a factor in the guidelines. Additionally, there was concerns with double counting of victim vulnerabilities. And it was noted that double counting is an issue in other aspects of Maryland sentencing guidelines, for example, weapon presence. The counter argument was that victim vulnerability points are not double counted, rather they provide guidance as to the range of sentencing as opposed to determining the elements of the offense. It was noted that many current vulnerabilities are elements of an offense, such as age, and are things that judges do consider at sentencing. So judges may consider both the elements of the offense and those same things as mitigating or aggregating factors. Finally, Senator Kelly suggested that given that unconsciousness is an obvious vulnerability, it wasn't something that we originally identified in the first memorandum that went to the subcommittee. It should be included as a list of conditions that met the standard for victim vulnerability, and the subcommittee did agree with that suggestion. At the conclusion of the discussion, the subcommittee generally agreed that it would be helpful to list specific conditions that constitute victim vulnerability in the guidelines manual, and agreed to recommend the following proposed revision to the guidelines manual, chapter 6, section 6.1D, and specifically subsection C would be revised to read, a vulnerable victim is anyone having a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. Examples of a temporary physical or mental limitation include, but are not limited to, instances when the offender knew or should have known the victim was pregnant, unconscious, asleep, and or intoxicated. In that revision, please note that the subcommittee recommended replacing the word handicap with disability in the first section. That hadn't really less to do with about this issue that was brought up and more just about being consistent with language that is recommended by the American with Disabilities Act to replace handicap with disability. The rest of the revision is language that the subcommittee specifically discussed, and that is on page 5 of the memorandum. The subcommittee asked that I present this proposed revision as the recommendation of the subcommittee, while noting that Mr. Fincy did express reservations to the proposed revisions. So I present that as the recommendation and open it up for comment questions.
Okay, well, I have a comment. This is Bill Davis talking. I have a concern with the word asleep. I don't see how that is a disability, even of a limited material way. I mean, when somebody's asleep, they're asleep. Maybe they're a heavy sleeper, maybe they're not. But it doesn't become a disability, either a physical or mental disability, and which is then later physically or mentally limiting in a material way. It has to be material. I don't think if you're asleep, that is in any way limiting you in a material way. I can understand unconscious, and I can understand intoxicated. I don't think asleep falls within that category. So I would propose that we exclude the word asleep from the definition or the examples of that.
If I could say, we were thinking about, while the term being used was disability, we were thinking of what made a victim more vulnerable than just the average presentation of a human being who has all of their faculties at the time of the crime and are able to defend themselves. So if someone were asleep and you did anything to them that was physically or psychologically abusive, it would seem that they are in a vulnerable state and can't defend themselves.
But the definition goes on to cite that it has to be mentally limited in a material way. Being asleep is a temporary, albeit it's not in any way material to the disability. So it just doesn't fit the final definition of limited in a material way. I don't see that.
At the time of the offense, however, any of the factors that we discussed and that we're considering would cause a person to be more vulnerable than if that factor were not there, and more vulnerable than the general public would be under similar circumstances. So if you were asleep and someone did almost anything to you that you could consider physically or psychologically, well, especially physically abusive, you are more vulnerable than if you're awake. In the first place, you might not even know who did it, so you couldn't even tell if you were awake and later what happened and who has injured you.
I understand your point. I'm just never going to get there. I don't see it as being a material, limited in a material way. I don't see it as a physical or mental disability in any explanation that may be provided. I just don't see it.
I thought that the more general thing we were trying to get at were states of a victim that make that victim more vulnerable than they otherwise would be.
Yeah. I understand your point. I'm not there. Yeah, no, it hasn't convinced me that sleep should be part of that definition or should be an example that is used.
Mr. Fincy, I saw your hand up.
Just,
And I know
yes,
that,
thank you, Judge.
Delegate Moon also has some comment. We'll get to him in just a second.
I think that Bill captures in a small way what my bigger concern was, as I expressed to the subcommittee. David captured a good part of the things that I expressed, but overall, what we're really doing here, though, is not making a descriptive change to the guidelines when we change guidelines, we usually do. I think and the prime example is using the word asleep, we are adding a proscriptive provision to what the sentencing guidelines are going to be in Maryland. We are telling judges all around the state that the guidelines are higher and the sentences should be higher when any of these special vulnerabilities are seen. And they're not telling us that that's what they're doing across the board and that this should be adding to our guidelines. We're telling them, and that's something that we've always tried to avoid, I thought. Now, the language that we reached here, I understand Bill's point, and the language we all agreed to as we got past that during the subcommittee meeting, no question about that. But my concern was adding pregnancy and adding asleep is, again, being proscriptive towards what judges should be doing throughout the state as opposed to descriptive of what they are doing.
Great. Further comment, Delegate Moon, I know you messaged that you wanted to speak up.
Yes, I can't stick my hand up since my camera's not on. But I did want to just, this is a fascinating conversation to me. I will say the pregnancy bit really jumps out at me. And I need to sit and just ruminate on this for some bit, but just by way of context, one of the reasons it jumps out at me is that you're noting that it came by request of Howard County. And I will tell you, we had a raging legislative debate over the last few years, and I was, participant in some of the conference committee hijinks, but because of a Howard County case involving exactly these circumstances, a pregnant woman getting murdered and the family wanting sort of justice in some way, in addition to the underlying murder of the woman, after getting tortured about this, we changed the law effective October 2019 to add 10 years to raise the possibility of adding 10 years to a sentence if you knew or believed someone to be pregnant. So the actual pregnancy wasn't actually even a requirement, but if it was part of your belief, that was a change in law that was, I think, made to satisfy the same Howard County sense of injustice. So I throw that out there, and this almost feels like we're going at this now from two different angles to get at the same narrow scenario. But in some ways, it was addressed through the underlying code itself. So I would just throw that out there for consideration. And I guess now we've got sleepiness and consciousness added in as additional things. But at least to murder, that was a recent change. Oh, and sorry, let me just also throw onto there, part of the debate we obviously had about this was whether this was a backdoor effort to give rise to some sort of legal consequence for two beings versus one. And so, as you can imagine, once we went down this road, the groups on both sides of the abortion debate were getting involved, the Catholic Conference got involved, and that's why we ended up dropping this concept of there being two lives and sticking with the whether you had knowledge or belief of someone's pregnancy. So anyway, sorry, I just throw that out there. But these seem to me be different things: the pregnancy and the sleepiness.
Okay. Further comment? Judge Avery, did you want to add anything from the subcommittee?
I do, but I think that the question that was posed by David Moon had to do with perhaps the origin and the source of this information. I think David Soleil should address that, and then I'd also like to comment. So if you could just come back to me.
Sure, Dr. Soleil.
Yeah, so I did want to just say that the point made by Delegate Moon is a good point. It is something that did come up during the subcommittee discussion. That was a 2019 law that created the 10-year felony. And the one point I wanted to make was that that is an additional penalty that may be added on in addition to the underlying act, but it is a maybe separate from and consecutive or concurrent with the sentence for the underlying act. And the main point I really want to make is that the guidelines would not reflect in any way the additional severity of the case for being a act against a pregnant person, because it would be all part of one criminal event. And the new offense that was created, it's a 10-year felony. The commission categorized that as a category 4 offense. So even if the underlying act was, say, a murder, a category 1, you wouldn't add together the guidelines ranges from those two offenses. So the guidelines would not be adjusted to account for this additional element that was introduced with the pass of this 2019 law. So that was just the one point I wanted to make with respect to that.
So I'd like to address the kind of political context of this issue that Delegate Moon raised. I will say, as the chair of the guideline subcommittee, that some of the factors that you mentioned that were presented to the legislature on this similar kind of subject matter that came before the legislature, having to do with the life of the child being a factor, that was not a consideration that was discussed in our subcommittee. And I don't want to speak for the other members of the subcommittee, but I don't think that that was even something we were thinking about. And so our proposal, I think I can fairly say, is not motivated from that aspect of the question. From my personal experience, the issue of pregnancy as a special vulnerability comes from two aspects. Number one, in all of this, it really emanates from the domestic violence setting. Number one, the lethality factors in domestic violence murders. Pregnancy is a huge factor. So pregnant women are, in fact, statistically more vulnerable to abuse and violence from their domestic partner or spouse. So there's that aspect, that there is a special vulnerability for pregnant women in the context of domestic violence. You know, who knows? I'm not a social scientist, so I can't tell you why that is, but we know that it is a very strong data point that comes up in all the domestic violence research and the research on lethality. The other there's the aspect of the violence, but there's also the aspect of the stronger kind of power and control that is exerted when you have a victim who is pregnant. She's worried about her child, her housing, her family, her you know, all of the factors that keep women in the household with domestic abusers or in a continued dysfunctional relationship with domestic abusers has to do with pregnancy. That is just a huge topic that has been discussed in the domestic violence advocacy community for 35 years now. So there's that aspect of it, but then the other side of it, I would say from the judicial point of view, is that assault on pregnant women, I think, just adds to the kind of seriousness or depravity of that particular type of violence. And so all of those things together, I think that the pregnancy as a special vulnerability of the victim, short of having, you know, a huge research project on this, I think it's fair to say that judges are going to consider the pregnancy of the victim as a special consideration, and as a vulnerability of the victim in sentencing. So to me, the pregnancy issue is, I know that, I mean, I hear you, Delegate Moon, because I wasn't aware that this was a big legislative issue, but this has been a topic, aside from whatever politics came out of Howard County, this has been a topic that has been present in sentencing communities, as well as in domestic violence advocacy groups for a really long time. So I think our proposal is kind of, I don't view it as political. I don't think that this is something, I think it's a really legitimate concern. We do need to change the language of that provision one way or the other. And so I think that we are appropriately changing the ADA language, as well as expanding the definition of vulnerability in a way that accurately reflects the sentencing considerations.
Judge Adrie, if I may, you did remind me of one other point that came up during the subcommittee call, and that is that statute that Delegate Moon referenced, the Lauren Reed's law, it applies only to when the underlying offense is a crime of violence pursuant to Criminal Law Article 14-101. And what is not included in there is second-degree assault. And many domestic violence charges end up as second-degree assault. So there is no additional 10-year penalty for committing a secondary assault against a pregnant person. So that would not be captured in there as well. So that was something that we also did discuss during the subcommittee. So just wanted to share that.
Thanks. And if I could just quickly follow up also, part of the reason I flagged the legislative debate was because, in fact, Judge, I raised some of the arguments you just made and tried to inject the perspective that there was a gender-based crime going on here. And so we should take a look at it. But it did, in fact, trigger that large debate about life. Now, because it was focused on murder, that would have been more at the fore. But I think Dr. Soulei's point that it goes all the way down to assault probably softens that argument. Anyway, I just thought I thought folks should be aware of the sort of other raging debates we had about this because of the Howard County case.
Is there any further comment?
Mr. Johnson raised his hand.
Oh, okay. I'm sorry. I didn't see it on my screen. Go ahead, Dr. Johnson.
Yeah, thanks. I have a couple comments. I guess I share a little bit of Mr. Fincy's concern that this is building into into the guidelines of prescriptive nature to these things. So if you're thinking about like being intoxicated, you could imagine a situation where there's a bar fight, right? Two people are drinking at the bar, they get into a fight, and now it seems like you're obligated, if you put this in writing, that's a worse assault, right, or a worse offense than assaulting somebody outside that context. So I'm wondering, I guess my bigger question is this, which is whether or not this is something that we want to build in explicitly into the vulnerable victim point, or as Mr. Souley was saying earlier, judges can still consider these things as departures, right? As upward reasons for upward departures if they're particularly egregious in a particular case. So I guess my question is, where do you draw the line between using these factors or considering these factors for reasons for upward departure? Or should this be prescriptive that in any situation where there's an intoxicated victim or somebody asleep, this necessarily adds a point to their score? And then I guess my last comment is, I had the same reaction to Mr. Moon, and I'm not certain why, but being asleep seems very different than being pregnant. The arguments for a pregnant victim to me are straightforward. Being asleep to me is a little bit harder to imagine. that's a situation in which the victim is necessarily more vulnerable. But those are just my comments.
Go ahead, Judge Avery.
Thank you. Dr. Johnson, I don't mean to be antagonistic, but I think that that this does kind of point out a certain gender divide, because I think that a lot of men can't imagine the special vulnerability of being asleep. But I guarantee you that if you polled women, that women would definitely imagine the sleeping as putting you in a vulnerable position. And so I'm kind of putting, I'm not going to die on the hill of being asleep. I mean, I would fight for the unconscious and or intoxicated aspect, because clearly these are factors that in particular, not exclusively, but more often make women more vulnerable to violent and sexual crime. And for women, these factors are not at all, these seem obvious to us, I think. I mean, I don't want to go too far with this, but I believe that these are aspects of sentencing that judges should consider from a prescriptive point of view. That's my personal opinion. I will add that for ever, some of these factors have been considered to downgrade an offense when it is committed against a woman, when it is of a violent or sexual nature. That the victim's intoxication or unconsciousness, and sometimes even pregnancy, like why were you pregnant with this person's child? I mean, it's amazing how these factors can get turned against women when they themselves are victims of crime. And so that's my perspective on it, is that in the context of the obvious criminal conduct against vulnerable women, mostly in these circumstances, we should be considering these. But even if you're looking at it from a descriptive point of view, I think that those are considered by judges in a more modern world to constitute a vulnerable status for the victim. So I'm just relaying to you my point of view, and I think the context in which the subcommittee discussed these issues. And again, I'm not going to go to the mat on the asleep, but I would definitely go to the mat on the unconsciousness.
Okay.
Judge Wilson, I'm not sure if you could see it, but we had two people that raised their virtual hands.
Yeah, I cannot on here. I'm only getting about 6 people on the screen at a time. So if you want to go ahead, Dr. Slay, I think you have everyone. Could you call on the next person who would raise a hand?
Yeah, so Melinda Grenier, I saw that you had raised your hand.
Yes. Yes, thank you. I certainly just wanted to give a perspective, having been a victim advocate for a number of years, specifically specializing in domestic violence cases. And as I grew and learned in that position, I was just amazed at the number of, number one, pregnant victims that we had, coupled with intoxicated and unconscious. It was mind-boggling to me how that particular those characteristics were so common among so many of the victims which I serviced in Frederick County. So I just wanted to share that with the conversation, add it to the conversation.
Thank you. We appreciate that. I see Rick Fincy also has his virtual hand raised. Rick, you're on mute. You got to unmute yourself.
Thank you. Sorry. Pass
Sure.
to the next person that hasn't had a chance to speak yet, please.
You're the only person with their hand up right now.
Oh, okay. Well, I mean, I appreciate what I heard from Judge Avery. Those perspectives, and also from Ms. Grenier, I've not understood completely. And so I appreciate that. In those perspectives, I can in fact, agree with what is being said. But on the other hand, the breadth of this special vulnerability definition is much broader than, when you talk about intoxicated, as I think Dr. Johnson mentioned. So we're in trying to protect those who should be protected. We are also expanding into areas that are going to impact upon situations that are unintended by this proposed change. So maybe there's a way to narrow down what we're trying to say in this vulnerable victim, because we're really talking about, pregnancy and women who are have been intoxicated or unconscious, to protect them, not so much the drunk in the bar who is in a fight with another drunk in the bar, and then there's the result is an assault conviction and a vulnerable victim because the bar patron was intoxicated. That's not what we're talking about. So perhaps we can narrow down the definition a bit.
Let me just put in 2 cents. I can tell you from personal experience, years as a prosecutor, that judges do, at least the judges in my jurisdiction do take into account whether at the time a crime begins, the criminal offense begins, if the victim is sleeping or unconscious. And I don't know if there's a medical difference between the two, but if they are asleep, they do comment on that, certainly in sentencing, and take that into consideration, and have for years now. When we're talking about protecting victims, and obviously our job's not to protect victims as much as it is simply recognize certain circumstances surrounding victimization. Many child sex abuse cases where someone in the household begin with the person asleep. And if it does progress beyond that, where either they wake up or it becomes more of an ongoing molestation, the fact is that the crime began when the person was asleep, when they were particularly vulnerable. I'm not sure how I can say that being asleep is not a temporary disability, because they are absolutely unaware of their surroundings and unaware of what is about to be done to them. So from the chair's two cents, the language that the subcommittee put together, I believe, makes sense based on my experience and what I've seen. I would be curious to hear from State's Attorney DiLeonardo, who of course has had perspective from both defense side and prosecution side in a different jurisdiction, just to see what his experience has been in cases involving either pregnancy, sleep, or unconsciousness.
Yeah, thank you, Judge. I was going to try to chime in after everybody was done, since I'm on the phone. I sort of expressed those issues in our subcommittee. The issue of that was raised about domestic violence and pregnancy is something that is a major issue. And to Delegate Moon's point, I can tell you the issue of pregnancy and domestic violence was really kind of independent, even though that sort of resulted in a homicide in a different kind of legislation. The issue of pregnancy has been seen as a major issue in domestic violence. And I can absolutely say, having been on both sides, that a domestic violence incident involving someone who is pregnant, I've always found the judges to consider that as an aggravating factor and sentence accordingly. So I certainly think that's the case. As far as the issues of unconscious or asleep, again, we've had issues, as Your Honor indicated, of people that have been asleep and the assault commences or is done. The question sometimes becomes, are they asleep or did they pass out from being intoxicated? Are we splitting hairs? I think ultimately and this is not I would challenge that it's prescriptive. I think it is I think it describes the kind of things that a court could consider as a reason for departure, which they already do. But someone who has been drinking, maybe they're not, you can't necessarily prove intoxicated, but they definitely were out and sleeping hard, and they get sexually molested. We've had situations where, a female is asleep and someone comes in and begins sexual contact with them. So I think that's what it's aimed at. I mean, it's aimed at situations. In the end, we're talking about a vulnerable person. And I think certainly someone in those situations that is asleep, whether had some to drink, maybe they're not fully intoxicated, but they're certainly out sleeping and gets some unwanted sexual contact. I think that's an aggravator that a court considers, as opposed to someone, as Senator Kelly noted, who is alert and in some ways able to perhaps take some action. I think there's a special kind of consideration a court has generally given when someone is defenseless. And I think that's what we're getting at with this. So obviously I support exactly what we recommended.
Okay, Dr. Slay, were you looking for a vote on this tonight?
Yeah, the subcommittee did present this as an action item for vote, yes.
Well, let me ask this, if there's a motion that could be entertained concerning this request or suggestion by the subcommittee.
Mr. Bryan, I'll certainly make a motion to adopt the recommendations of the subcommittee.
Okay, is there any further discussion on the motion?
I would offer a second.
Okay. We're going to do this again in the negative. And as Dr. Saleh outlined in his instructions, if there's a number of people who are nay, then staff will call for a roll call vote and go down one at a time. So please listen to the question. Is there anyone who is against the motion to adopt the language recommended by the subcommittee? If so, answer nay.
Nay.
Okay.
I have Bill Davis recorded as a no.
Okay. Seeing none other, I believe we can accept that, Dr. Slay, is that correct?
Yes.
Passage. All right. So that language amendment does pass.
Okay.
Dr. Avery? Or Judge Avery? Sorry, I got doctors and judges all over the place.
Well, there is one more item. I don't mean to interrupt, but if you want, Judge Avery, I could go ahead and proceed with the presentation for the ABA plea issue. Is that okay?
Please, thank you.
Okay. So the second item on the subcommittee agenda is the continued review of the definition of American Bar Association or ABA plea agreements and the ABA plea agreement compliance rule. And I refer you to the memorandum that was distributed that is labeled Memo of ABA Pleas Status Report. There's also a corresponding supplemental information on the ABA Pleas document. The Sentencing Commission staff routinely receives inquiries from practitioners concerning what constitutes an ABA plea, and in particular, the level of specificity required for a plea agreement to be considered an ABA plea. For example, is an agreement to cap the sentence at the upper guidelines limit an ABA plea agreement? Or is that an agreement that is too broad to qualify as an ABA plea? Because of questions like this, the Sentencing Commission 2009 annual report indicated our plan to review in 2020 the current definition of binding ABA pleas, with the understanding that that review would necessitate a fuller discussion regarding the longstanding ABA plea compliance rule. So for purposes of review, the ABA compliance rule indicates that sentences that are adjudicated pursuant to an ABA plea agreement are deemed guidelines compliant, regardless of whether the guidelines applicable sentence falls within the guidelines range. As you all know, during the 2020 legislative session, House Bill 1458 was introduced that provided that a sentence imposed pursuant to a plea agreement may not be deemed compliant with the sentencing guidelines unless the sentence falls within the actual range. So that bill was really intended primarily at the commission's ABA compliance rule. The commission submitted a written statement opposing that legislation, but also indicated that the commission had already planned to review ABA pleas in general and the longstanding ABA plea compliance rule. The commission's testimony further noted that we request that the legislature defer to allow the commission to study the issue and to report its findings by the start of the 2021 General Assembly session. House Bill 1458 did not advance out of the judiciary, but we did still proceed with our plan to study this issue. The subcommittee had robust discussions about the ABA plea definition and the compliance rule, both at its June 18, 2020 meeting and continued the discussion at a most recent August 31st, 2020 meeting. The two questions that were considered were: one, should the Sentencing Commission clarify the definition of an ABA plea agreement and or provide specific examples of what constitutes an ABA plea? The second question was the broader question of whether sentencing events resolved by an ABA plea agreement should continue to be deemed compliant even if the sentence falls outside the guidelines range. So to assist with those discussions, the staff provided the guidelines subcommittee with information on the definition of binding pleas in the federal system and in 3 neighboring jurisdictions. And more details on that research review is provided in that supplemental document that was sent to everyone. The staff also reviewed the ABA standards for guilty pleas and did not identify any language that expressly defines a binding plea under the current ABA standards. The guidelines subcommittee discussion focused largely on the federal rule regarding plea agreements, specifically binding plea agreements that are covered in Rule 11C1C. And so that was something that the subcommittee reviewed in detail. And again, if you're interested in the specific language in that, I don't think it's necessary to review right now, but that is provided for you in the supplemental materials. To help inform the discussion of the second question about whether the ABA compliance rule should continue to go forward, the staff also provided some data analysis about how sentences for sentencing events resolved by ABA plea compare with the sentences for sentencing events that are not resolved by an ABA plea. And we looked at 3 years of data, 2017 through 2019. Again, the fuller information on this is provided in that supplemental memo that was distributed. The analysis considered the use of ABA pleas by type of offense, by the judicial circuit, and by the defendant's race. Kind of summed it up as in 4 key findings from that analysis. Most of them are probably pretty obvious, but the first was that sentencing events resolved by an ABA plea are less likely to be within the guidelines range, which is not surprising, than sentencing events resolved by other dispositions. So that's 57.3% of ABA pleas are within the range compared to just less than 68% of other dispositions. The difference in what we're calling strict guidelines compliance, which means the sentence fell within the actual guidelines range, for sentencing events resolved by an ABA plea agreement versus other dispositions is largest for drug offenses. Among drug offenses, 46.3% of ABA pleas are within the guidelines range compared to 66.2% of other dispositions. ABA plea agreements are also much more frequent in the 8th Circuit than elsewhere. Just less than 80% of dispositions in the 8th Circuit are ABA pleas, whereas the use of ABA pleas in other circuits ranges from a low of 10.4% to the second highest level of 56.3%. And the final key finding that we have was that ABA plea agreements are more common for non-white defendants than for white defendants. Approximately 50% of sentencing events for non-white defendants are resolved by an ABA plea compared with 36.4% of sentencing events for non-white defendants. So as I noted, the subcommittee discussed the ABA plea agreement definition and the compliance rules at the last 2 meetings. There were a couple things the subcommittee agreed on. The subcommittee agreed that the term ABA plea agreement is not universally known and should be replaced. That was something that everyone agreed with unanimously, that that is not a universally understood term. And so the subcommittee thinks that potentially that could be replaced with some more definitive language like a 3-party binding plea agreement to make it very clear what it is. Further, the subcommittee agreed that the definition of what constitutes a guidelines compliant plea could be tightened, specifically or potentially to include a specific agreement as to both the charges and the specific sentence, not merely a sentence cap or a sentence range. The staff was asked to review relevant case law and draft a revised sentencing commission definition, what we would have in the manual of a 3-party binding plea as it relates to the guidelines compliance rule. And we were asked to do a little research on that, to look at case law and to present that to the subcommittee at its next meeting. Regarding the ABA plea agreement compliance rule, it was noted that the commission will conduct its next, what we call cell-by-cell compliance analysis. That means to look at each of the interlocking cells within each of the 3 grids, the drug, property, and person matrix, where we look at the compliance rates and the average sentences within each of those individual cells. And we are scheduled to do that in 2021. In the past, the commission has been guided by 2 principles when conducting that cell-by-cell analysis. Those 2 principles are the compliance rate within the individual cell and the average sentence length within the individual cell. Because of the ABA compliance rule, in the past, few of the individual cells have actually fell below the commission's benchmark standard of 65%. During this next analysis, the commission may decide to be guided primarily by the average sentence length. An analysis guided primarily by the average sentence length would be consistent with the descriptive nature of the sentencing guidelines. The guidelines subcommittee expects to present a recommendation of revised language for the term and the definition of a guidelines compliant plea at the commission's December 8, 2020 meeting. So I present that as the status report of the subcommittee with our subcommittee's intention to come back with a specific proposal at the December meeting.
Okay, and so just so everyone knows, certainly we'll have comment, but it's not intended as an action item for tonight, but we certainly invite comment to make sure everyone is in agreement with how the subcommittee decided to proceed on this. So is there any comment? And again, I can't see all of the faces. So Dr. Slay, if you see anyone putting their little hand up or anything, please go ahead and call on them.
Right, I will. I'll just remind commissioners that if you raise your hand virtually through Zoom, I will definitely see you, but I'll keep scanning back and forth.
And I think silence is still consent, right?
Oh, thank you, Senator. Okay. All right, well, I appreciate the work of the subcommittee on that. It has, just in the short time I've been here, it certainly has taken a lot of discussion time up. And this sounds like a very, very positive way to move forward on it. So we look forward to the suggested language.
Judge Wilson, I'm not seeing any hands raised at this time.
All right. Judge Avery, did you have anything else from your subcommittee?
Don't, but I do just want to say thank you to Dr. Soulé, because that was a really fantastic summary of a very long and deeply considered discussion among all of us. So thank you so much.
And those are very good descriptors. So, okay. So moving on, Dr. Soulé, not that you haven't been required to speak enough already, but now it's up to your executive report.
Okay, great. I appreciate it. We'll have 5 items to report to the commission today. They're all status items, but there is one, the last item that I am looking for input from the commission. So the first item I would like to report on is the proposal to report jurisdiction-specific analyses. As a reminder, on August 11th, I emailed the commission to ask for input on a proposal to amend the commission's informal policy regarding jurisdiction-specific reporting of sentencing guidelines data. And for those of you who are new to the commission or may not be familiar with this policy, the commission maintains this informal policy that excludes jurisdiction-specific analyses in the Sentencing Commission reports and publications. The commission reports, the published reports, instead utilize judicial circuit as the unit of analysis for any geographic analyses. The commission adopted this informal policy many years ago, before my time, but I think it's been in place since the inception of the commission. And I think Senator Kelly has confirmed that, since she's someone that's been here the entirety of the time. This was adopted because in 7 of the 24 jurisdictions, the circuit court is a one-judge shop. Jurisdiction-specific analysis would therefore be tantamount to judge-specific analyses in those 7 jurisdictions. It should, however, be noted that on occasion, visiting judges also sit in those 7 jurisdictions. So no jurisdiction is truly a one-judge shop, but there is predominantly one sitting judge in those 7 jurisdictions. When I sent my email on August 11th, I asked if there was any opposition to this proposal, and one of our commissioners did respond with a thoughtful response and indicating in opposition to the proposal. Additionally, I reached out to Judge Laura Ripken, who is the Anne Arundel County Circuit Court Administrative Judge. She's also the Administrative Judge for the 5th Circuit, and she is the chair of the Conference of Circuit Court Judges. Judge Ripken informed me that she discussed this proposal on a conference call with all of the county administrative judges, and they unanimously expressed opposition to jurisdiction-specific reporting. And contrary to what I had indicated in my email to the commission on August 11th, Judge Ripken indicated that there was concern from the smaller jurisdictions in particular. She additionally noted that there was concern that the information could be misinterpreted and that judges don't have the ability to respond to public comment. These are all things that we've discussed before at some point with the various legislative proposals for judge-specific reporting. Judge Ripken indicated that she appreciated the opportunity for the court administrative judges to share their input on this issue. I then subsequently communicated with Judge Wilson after hearing the feedback from our one commissioner and Judge Ripken regarding the position of the all 24 circuit court administrative judges. And based on that feedback, we believe it is probably best to withdraw the proposal to report jurisdiction-specific analyses. So that is our position at this time, and we just wanted to see if there was any concern from the commissioners that we would withdraw that proposal.
In light of that analysis, and also in light of the fact that even if someone else occasionally is sitting in a very small jurisdiction, that it probably is very easy to end up intentionally or non-intentionally keeping track of a person by the name of the specific judge. And so I would move, if it's in order, that we accept a recommendation and that we stick with the circuits and not with the specific county judge.
I don't know that a motion is necessary, Senator Kelly, because we're just withdrawing an informal suggestion, but I appreciate that.
David?
I see 2 hands raised. I think I saw Rick Fincy's hand up first.
That's okay. Judge Avery can go first.
Okay, well, I was just going to say, number one, I was not the person who expressed opposition, probably contrary to the assumptions that are made here. I actually was in support of it because our initial reconnaissance on this issue indicated that there would not be opposition to it. And so, yeah, I didn't think it was going to be a problem, but I'm going to say that as the circuit court representative on this commission, that maybe I should have done my own investigation among my colleagues to see how people felt about it. But in any event, I do support withdrawing the proposal.
I think Rick.
Yes, I'm asking, this is a question, whether we, by not doing this, are inviting, more legislative interruption into our business.
I could allow one of the.
Yeah, there really is a role for the legislature now, but I wouldn't think so.
Maybe gubernatorial is a better question than legislative.
Let me just interject for a second. Dr. Saleha, we've had the conversation, and I believe that the way it is currently done is consistent with the statutory language of the enacting statutes creating the commission. Is that correct?
Right, right.
So,
And I'm so old, I was there then. I sat on the commission that created this one.
Correct. So the statutory language does reference that we are to report by judicial circuit. So I think you can interpret it that was the minimum level, and we are meeting that minimum level. But that we are being consistent with that, with the statutory language. Correct.
and Rick, I would suggest that it doesn't matter what is done as far as attracting legislative attention. Inaction and action can both attract it equally, because there's so many diverse thought processes that inhabit the chambers of Annapolis.
Gotcha.
So I think we're okay there.
Okay.
I second your insight.
Okay, I don't see any other hands raised to address this. So I will move on to the next item that I would like to report on, and that is webinars, training webinars. The staff has been working hard to continue providing training during the COVID-19 pandemic, and with in-person trainings on hold for a while, the staff transitioned to providing interactive online webinars. And I'm pleased to report that the staff completed our first 2 webinars, one on August 5th and a second on August 12th. We had approximately 125 criminal justice practitioners who participated in the 2 webinars. The allotted participants for each webinar filled up very, very quickly. So we did upload a recording of the webinar on the Sentencing Commission YouTube channel. We have a YouTube channel now, by the way. So anyone can view the training on their own schedule. There's a link to it on the website. To date, there have been more than 130 views on YouTube, which is mind-blowing to the staff. So while the number of training sessions is down during COVID, the number of times that we're going out and delivering trainings, the positive is that we're reaching a broader audience than we were by going out and doing in-person trainings. We're getting to a larger number of people by having the webinars and also having the recording available on YouTube. So that's a positive. I'm also pleased to report that Judicial College invited the staff to provide a webinar for judges, and that is a week from today. It's titled "Making Informed Sentencing Decisions: Enhancing Sentencing Guidelines and Policy Knowledge," and that will be on September 22nd, a week from today. The third item that I wanted to, I'm sorry, Judge Wilson.
Just interject for one second. Will next Tuesday's program also then be uploaded to YouTube?
I don't think it will be uploaded to our YouTube because that's a Judicial College.
Oh, okay, right.
It will probably be uploaded to the Judicial College's
good.
library, digital library.
Okay, very good. Thank you.
But that is geared more towards judiciary,
right,
to judges. So it'll be available to the judges.
Right.
In that way. And sorry, I do see Rick Fincy raised his hand. Nope. Okay. Yeah, that was a good question. Thank you. The third item to report is the criminal justice community survey, a criminal justice survey that we distributed back in May. I did want to just give you an update. I didn't want you to think it just disappeared. The staff has been working on analyzing that. It was a lot of open-ended questions to that. So there is some, we're trying to figure out the best way to present that information, but we do anticipate that we will be providing a report on the survey results to the commission at the December 8th meeting. The fourth item is the sentencing snapshot. As I noted at our last meeting, the staff began production of a series of topical mini reports that we entitled Sentencing Snapshot. They are have the goal of to give a quick review of sentencing trends and other topics of interest. The first issue was released on July 20th. That looked at crimes of violence and firearm offenses. And the next issue is planned for October, which will examine the other person offenses. In other words, those that are not classified as crimes of violence and firearm offenses. All these sentencing snapshots are posted to the commission website, and you can get, there's a link for it on the commission's homepage, so you can quickly find out where those are on the website. The last item that I wanted to discuss was the protocol for the December 8th meeting. For those that are new to the meeting, the December meeting, excuse me, is the time when we do both a public comments hearing and a business meeting. The Sentencing Commission's enabling legislation requires us to hold annually a public comments hearing, and it's an important opportunity, and it's a good forum for the public to be able to address the commission about any sentencing related issues. That meeting again is scheduled for December 8th at 5 p.m. We'll follow it with our regular business meeting. Next month, we will distribute a invitation to approximately 35 criminal justice stakeholders throughout the state. Further, in keeping with what we've done the last year or two, we will also email our email listserv, which is approximately 1,000 criminal justice practitioners who are receive the guidelines e-news. So we'll email all them to make them aware of the public comments hearing. I encourage commissioners I will send the invitation to all the commissioners, and I certainly encourage you to share it with anyone you deem appropriate. We'll also announce it on our website, the Maryland Register, the General Assembly's hearing schedule. We try and get the word out there as much as we can. So there are just a few administrative items that I would like to address and get some feedback on, and this is the input part I was looking for. The first is, and I communicated with Judge Wilson about this, that we agreed that we should plan for this public hearing to be done as probably as a Zoom webinar like this again. The staff has researched virtual platform options for the public hearing, and we believe Zoom webinar. We're currently using Zoom meeting. Zoom webinar just gives us a little bit more features, and we are able to utilize that through our relationship with the University of Maryland. It provides a mechanism to allow for speaker registration. It provides a couple neat details that we can utilize, and I think could work well for the public comments type format. Judge Wilson and I have discussed that if something changes and an in-person option becomes available, we may consider that option, and I guess we would reserve the right to change it to an in-person meeting, but that would probably need to be done by November 1, kind of at the latest, to give us time to announce, publish, in the Maryland Register and all the other formats that I mentioned, to announce that how the meeting will be accomplished, whether it's in person or via Zoom webinar, and how a person will register, et cetera. So,
Doctor.
Yes, go ahead.
Yeah. It's highly unlikely that, given the normal format we've been using, the judiciary room and so on, the General Assembly, the leaders are busy right now trying to figure out all together how to meet all of the constitutional requirements of what we're going to need to do by January, and to also keep everybody as COVID-free as possible. They're talking about whether we got to put plexiglass around everything. I think it's probably easier for us to have an uninterrupted meeting without a lot of distractions if we were to do what you were initially proposing, and to do it with Zoom.
Right. Yeah, I tend to agree with you. I mean, if there's a positive, doing it virtually opens up the opportunity for people who may not be willing to travel to Annapolis to participate. So, there is some positive to doing it virtually, potentially reach a broader audience to allow them to participate. So. Okay. The next item I wanted to request input on is whether the staff should plan to begin the public hearing with a presentation on the history, purpose, and goals of the sentencing guidelines in the commission. The idea for a presentation was suggested, I think in the past, I think Judge Avery, this might have been your idea. Please correct me if I'm wrong, but just to provide a brief background for those who might not be familiar with the work of the commission. So the staff was thinking this would be a 5-minute presentation to kind of kick off the meeting, just for anyone who may not be familiar of how the process works, to try and touch on some of the, those main points. I just wanted to see if there was any thoughts about that idea for the start of the public hearing. Yes, Judge Avery.
Okay. I think this is really important, that, may even justify more than 5 minutes. But I would like to address the history of the sentencing guidelines and how the commission came about. I would like to acknowledge Senator Kelly as our resident historian and
This whole.
And is very wise and has a lot of insight in terms of what our purpose is for being here. I think it's important for the members of the commission to understand that history, as well as members of the public. I mean, it's just obvious that we should be concerned with that. But I also think that we need to expressly address the statute itself. We exist because the legislature passed a law to create us. And it's very important for all of the members of this commission to understand the provisions of that statute and where they came from, why they exist. So, I don't know if you can get that in 5 minutes. I'm a fast talker sometimes. Maybe you can just, get through it. But
Right.
those are all my important topics.
I like that. I think it's a good idea. I think we can keep it relatively brief and still cover a lot of that.
Any other discussion on that? I think it's a great idea, and certainly 5 to 10 minutes could be spared without a problem. Anyone else want to weigh in?
I did have one final item that it's not really a question for input, but rather a request. Just as I said, when we have the invitation, we will distribute it to commissioners, and we encourage you to, to pass that along to people that you might think who would be interested in attending, but really to encourage commissioners to identify potential thoughtful speakers who can speak directly to sentencing issues that are within the scope of the work of the Sentencing Commission. So I would just ask you to think about that and feel free to, give my email or phone number to anyone that might be interested and have questions about how that would work, and I'm happy to speak with them. So I just would encourage you to think about people that might be interested and would be appropriate to speak at the public comments hearing. And that's it. That concludes the executive director report.
Okay, is there any old business we need to go over again? You know of any, Dr. Saleh?
I do not.
Okay. How about new business? No. How about announcements other than the December 8th meeting? Are there any other announcements that we need to broadcast? All right, well, seeing none, I would call this meeting adjourned. Thank you all very much for your participation.
Yes, thank you. Appreciate it.
Everybody have a nice night. Thank you.
Okay.
Thank you.
Take care.
Good night.
Good night.
Night.
Bye.
Everybody.